Before there was a warning, there was a question, and the man who would have to answer it was the Chief Justice of the United States, Earl Warren. In the spring of 1966, he sat down to write an opinion that would run to dozens of pages, and he began by naming exactly what was at stake. He did not open with the facts of any single arrest. He opened with the size of the thing. He wrote that the cases before the court reached down to the foundations of American justice itself, and then he set it down in plain language. Here are his words. The cases before us raise questions which go to the roots of our concepts of American criminal jurisprudence. The restraint society must observe consistent with the federal Constitution in prosecuting individuals for crime. Read that again slowly. The restraint society must observe, not the restraints on the criminal, but the restraints on the state. Warren was not asking what a suspect owes the police. He was asking what the government owes a person, even a person it believes is guilty. To understand why that question cut so deep, you have to leave the 20th century entirely. The idea that a person cannot be forced to condemn himself is not American. It is far older than America. It runs back through English law more than 300 years to a printer named John Lilburne. In 1637, Lilburne was hauled before the Court of Star Chamber, the king's own instrument for crushing dissent. They demanded he take an oath. Swear first, the court insisted, and then answer whatever we ask, even if your answers send you to prison or worse. Lilburne refused. A man's conscience, he argued, should not be racked by an oath that forced him to become the engine of his own destruction. He was whipped through the streets of London for that refusal. But the principle he defended survived him, and centuries later it would be written into the American Bill of Rights, in the Fifth Amendment's promise that no person shall be compelled to be a witness against himself. That is the privilege at the heart of this case. Old, hard-won, and by 1966, the justices feared, quietly going hollow. Because a right means very little if the person who holds it never knows he has it. There was a second problem, and it was uglier. For most of American history, the surest way to get a confession was simply to beat one out of a suspect. In 1931, a national commission appointed to study law enforcement reported back to Congress. What it found had a name: the third degree, the infliction of pain, physical or mental, to wring a confession from a prisoner. Not a rare abuse in some distant precinct, but a practice the commission found flourishing across the country. And it was not only history. Warren pointed to a case decided just 1 year earlier in 1965. To be clear, this was not one of the cases before him. It was a separate matter out of Kings County, New York, called People v. Portelli, and he cited it as a warning that the old brutality had not vanished. In that case, the court noted, the police had beaten, kicked, and pressed lighted cigarette butts against a man under questioning, to force from him a statement against someone else. So this was the inheritance Earl Warren carried to his desk. An ancient right against self-incrimination, and a long, stubborn record of the state ignoring it, sometimes with fists, sometimes with lighted cigarettes. But by 1966, the court's deeper worry was not the fist. It was something quieter, something that left no marks at all. And to see it, you had to step inside. Just heard was not invented for this story. It is the Supreme Court's own account of a case it had decided 2 years earlier, in 1964. The case was called Escobedo versus Illinois. In Escobedo, the police had a suspect in custody, and the suspect had a lawyer he had already hired. The two men were in the same building. They were never allowed to meet. The officers questioned the suspect, secured a statement, and the state of Illinois used that statement to help convict him. When the case reached the Supreme Court, the justices drew a line. A confession taken after the police had refused a suspect access to his attorney could not stand. The statement was thrown out, but that decision left a much larger question sitting open. Escobedo had a lawyer at the station asking to be let in. Most suspects don't. So what about the man alone in the room, the one who never thought to ask, who didn't know there was anyone to ask for? That is the question that brought Ernesto Miranda to Washington. In the spring of 1963, police in Phoenix, Arizona, arrested Ernesto Miranda and brought him in for questioning. They took him to a room the court would later describe as specially set aside for interrogation, a place cut off from the outside world. There, over the course of that questioning, Miranda gave a written, signed confession. No one had told him he could stay silent. No one had told him he could have a lawyer in the room. The statement was later used to convict him. Now, it matters a great deal how we say this. The Supreme Court never decided whether Ernesto Miranda was guilty of any crime. The source we have doesn't even describe the underlying offense. What the court examined was the confession itself and how it was obtained. A statement pulled from a man who was never told he had the right to refuse to give it. And looking at that confession, the justices saw a pattern. Not fists, not the beatings of an earlier era, something quieter and in its own way more effective. The interrogation room, the court came to believe, had been engineered. To show what they meant, the justices did something unusual for a Supreme Court opinion. They opened the police training manuals, the books that taught officers how to question a suspect, and they quoted them at length. The manuals did not describe violence. They described a science of pressure. Put the suspect in a room that is unfamiliar and is alone, without a single friendly face. Display an absolute, unshakable confidence in his guilt. Never let him feel that he can simply stand up and walk out. One technique the court singled out even had a name. The officers called it Mutt and Jeff. 2 interrogators, 2 roles. The first is relentless and hostile, and he promises the suspect the harshest punishment the law allows, and he will not bend. Then the second man steps in, calm and reasonable, and offers to hold his partner back, if only the suspect will cooperate right now. Another was pure theater. A suspect placed in a lineup and then identified falsely by witnesses who did not exist, for crimes that had never happened, until he grew desperate enough to confess to the one offense actually under investigation. The court was careful here, and so should we be. There was no proof that any of these particular tricks were ever used on Ernesto Miranda or on any of the men whose cases were before the court. The manuals were evidence of something larger. They showed what the closed interrogation room was built to do, written down by the very people who built it. And reading those manuals, Chief Justice Earl Warren reached a conclusion, and he stated it without hedging. The isolation, the projected certainty, the kind face, and the cruel one, all of it served a single purpose. He wrote, and these are his exact words: "It is obvious that such an interrogation environment is created for no purpose other than to subjugate the individual to the will of his examiner. This atmosphere carries its own badge of intimidation." Subjugate the will. That is the language of a Chief Justice of the United States, describing what was happening inside ordinary American police stations, every day, behind doors that closed. There was an obvious objection to all of this, and the states made it. If a suspect wants a lawyer, let him ask for one. The right was already there for the taking. Why should the police be required to announce it? Warren's answer went straight to the heart of the problem. The entire purpose of the closed room was to question people who did not understand their own position. The man who knew enough to demand a lawyer was never the man the system had to worry about. He answered it in a single sentence, and I'll read it to you exactly as he wrote it. "The accused who does not know his rights, and therefore does not make a request, may be the person who most needs counsel." The person who most needs counsel. The silence of the uninformed, the court was saying, could not be treated as consent. And if the right was to mean anything at all, then someone would have to speak it out loud before the questioning began. The only questions left were who, and when, and in exactly 1966, the question had stopped being theoretical. It had moved out of the interrogation room and into the highest court in the country. On the last day of February and the first day of March, the justices of the Supreme Court sat to hear argument on what the Constitution allows the state to do to a man it has not yet convicted. And the court did something it rarely does. It took 4 separate cases from 4 different corners of American life and folded them into one. There was Miranda out of Phoenix, Arizona. There was Vignera out of New York. There was Westover, whose case ran through the federal system, and there was Stewart out of California. 4 different men, 4 different crimes, 4 different states, but one thread ran through all of them. Each had been taken into custody and questioned behind a closed door, and not one of them had been told before the questioning began that he could stay silent or that he could ask for a lawyer. It is worth pausing on what the court was and was not deciding. It was not weighing whether these men had done what they were accused of doing. It was deciding something larger. What restraints the Constitution places on the government in the moments before a person ever sees a courtroom? The answer would reach every police station in the nation. When the answer came, Chief Justice Earl Warren did not hide it inside pages of qualification. He stated the new rule in plain words, words that would soon be printed on cards and carried in the pockets of officers across the country. He wrote, and I am quoting him directly here, "Prior to any questioning, the person must be warned that he has a right to remain silent, that any statement he does make may be used as evidence against him, and that he has a right to the presence of an attorney, either retained or appointed." You know these words. You have heard them on television, in films, spoken fast over the click of handcuffs. They have become so familiar that we barely hear them anymore. But this opinion on this day is where they were born. Before this, no officer was required to say them at all. The court did not stop at the warning itself. It spelled out what the warning was meant to protect. The right to a lawyer, the justices said, was not something that waited politely for the trial to begin. It reached into the interrogation room, to the very chair where the suspect sat. A person could give these rights up. He could choose to talk. But the court placed a heavy weight on the government's shoulders. If the state wanted to use what a suspect said, it had to prove that he had given up his rights knowingly and intelligently and of his own free will. Silence could never be twisted into consent. And if the warnings were never given, then the words taken in that room could not be used against him at trial. It did not matter how damning they were. It did not matter whether they were true. Without the warning, the confession was sealed off as if it had never been spoken. For Ernesto Miranda, the consequence was direct. The confession that Phoenix police had drawn from him in that room cut off from the world had been taken without any of these safeguards. Under the rule the court had just announced, it could no longer stand. But the justices were not finished. Beneath the warning, beneath the procedures, lay a deeper reason, and Warren was by itself is just procedure. A set of words an officer recites before the first question is asked. But Chief Justice Warren did not stop at the procedure, because a rule without a reason is only a formality, easily worked around. So he reached past the rule, down to the thing it was built to protect. What he found was an idea older than the Constitution itself. The reason a state cannot force a person to become the instrument of his own conviction, Warren explained, has little to do with whether that person is guilty. It has to do with the character of the government doing the asking. He grounded the entire privilege in a single sentence. The Chief Justice wrote, quote, "The constitutional foundation underlying the privilege is the respect a government, state, or federal must accord to the dignity and integrity of its citizens." Dignity and integrity, two words that belong to philosophy, not police work, sitting at the foundation of a ruling about interrogation rooms. Warren was saying that how a government treats the person it suspects of the worst is, finally, a measure of the government itself. The closed room, the wearing down of the will, the confession taken from a man who was never told he could refuse, all of it failed that measure. Think back to the scene this story opened on. A suspect in a windowless room, handcuffed, questioned, standing for 4 hours. The lawyer